Hello, and welcome to our presentation on Trust and Estate Administration. I'm Tim Borchers, President of Northeast Private Trustees, sponsor of the program. Northeast Private Trustees is an independent trustee acting as a successor corporate fiduciary for clients' families. We are loyal to your legacy to wisely protect and pass down wealth. Our speaker is Attorney Mackenzie Hager. Mackenzie holds degrees from the University of Florida, Nova Southeastern, and Boston University, where she obtained her advanced degree in tax law. Happily for us, she decided to stay in Massachusetts. Mackenzie had significant tax and law firm experience before joining Borchers Cusano Trust Law, where she now heads up the Estate Administration Department. I hope you will enjoy Mackenzie's self-effacing humor as much as I do, and appreciate her informative presentation. Thank you for being with us.
Hi, everyone. My name's Mackenzie Hager. I am going to be talking about avoiding problem settling your parents' estate tonight. The first thing that we're going to do, just to make sure that I can gauge our audience, is we're going to do a little poll with 3 questions. It's a pop quiz, so I can see who we're presenting to tonight. So there are 3 questions. The first one is, are you currently a named trustee or a personal representative in a loved one's estate plan? The second one is, are you currently administering or have you ever administered a will or a trust for a loved one? And the last one is multiple choice, and we just want to know what your most concerning factors are when you think about settling an estate. You can choose multiple things. It could be all 5 or it could just be 1. So there's the results. It looks like we have a good mix. About 50%, a little more than 50% of people have or are named a trustee or a personal representative. And then the same, about 44%, 56% are currently administering or have administered. And then it looks like the big concerning factors are, wow, family dynamics and making an expensive mistake comes in first. Not that many people worried about time or cost. Lack of knowledge is a big one too. So thanks for that, everyone. Okay, now I'm going to go ahead and share my screen. So everyone should be able to see my screen at this point. It's a very nice couple with our logo and the title of tonight's presentation, Avoid Problem Settling Your Parents' Estate. A little bit about me. I've been at Borchers for almost 2 years. It'll be 2 years in June. I've helped with over 200 estates since I've been here, if you can believe that. So that gives me some street cred maybe. So the scope of the presentation, and some of you attending may be Borchers Cusano Trust clients. So if that's the case, generally speaking, these issues are unlikely to affect you if you're a trust support client with confirmed funding of your trust. So the discussion will surround decedents that had estate plans from other law firms or no estate plan at all. And the goal being that we want to highlight some of the problems that I've seen in my caseload and my paralegal's caseload. And then you'll be able to walk away with some ideas for your own estate plan, or if you're administering one, to share with your named trustees or personal representative or beneficiaries. Okay. So I just want to start with a general timeline. Again, this is highly generalized. All administrations are different, but we just need a starting point to kick this off. So in general, most estate and trust administrations can last anywhere between 6 to 18 months. That's, again, highly generalized. I can't stress that enough, but this is going to just go through the 3 steps, and I'm going to talk about it really in terms of days, so you can kind of get an idea of what we're looking at. So the first 30 days after death, you're going to be grieving with your family. You're going to want to get a death certificate. You may want to reach out to an attorney, but there's, not much you can really do until you have that death certificate. So just make sure that you keep that in mind. And there's a few more things that we want to highlight, but they're beyond the scope of this presentation. So we're going to link our ebook for more information, and it's specific to the first 30 days. So that'll be at the end of the slide. I'm going to make you wait for the prize at the end, but that should provide some more information about what you'll need to do in the first 30 days. So the next 60 to 90 days after death is really when the trustee and the personal representative are going to get organized. They're going to inventory assets. They're going to value the assets as of date of death. They're going to figure out how the assets were owned. And that's when we hit the big P, which is probate, which maybe some of you have heard of. That's when you're going to start that process. And that process is going to be subject to the court's timeline, not necessarily our timeline. So we want to make sure that we tack on some extra time for that. And then we're going to move on once we have probate completed to going through the claims paperwork to collect the assets. So if you're dealing with an estate, you're going to want to get the paperwork from the probate court before you start making the claims. If you're dealing with a trust, you should be covered if you're named trustee. Okay. So the next 90 to 120 days after death, we're going to work on, you're really in the thick of it. You're going to work on consolidating assets. You're going to make the big decisions, right? The big tax decisions, the big financial decisions. You're going to figure out what to do with those assets. If you have a house that's in the trust or in the estate, you're going to figure out if you're going to sell it. You're going to tack on some extra time if you're cleaning out or selling it, but that's really a big time crunch. If you're selling a house or multiple houses, you're going to pay bills, pay expenses, and you're going to talk to the beneficiaries. You're going to give them a lot of transparent information, which we're going to talk more about in the slides ahead. And then the step 3 is the one that everyone knows and loves, distributions. So there's 2 types of distributions that can occur with an estate plan. If you have a trust, sometimes those distributions are outright to beneficiaries, or sometimes they're to a beneficiary subtrust. So there's kind of a chunk of tasks that we have to get through if there's subtrusts. And that's usually when I receive feedback from trustees that it's a lot more involved than they thought it would be or that they expected. But it's not something that we're unfamiliar with. It's just something that we like to make people aware of. But the distributions can be a little bit involved if there's a trust, but it's a good thing. The protections are going to pass to the beneficiaries. If there's an estate and you're dealing with probate, it can be also a bear to get stuff out to the beneficiaries as well. You might have to do an accounting and speak to the beneficiaries about how they'd like to receive the assets when that time comes. So one other thing I like to highlight is that even if we're administering a trust in 6 months, the big tax returns usually are not due until the year following death. So for instance, if you have a decedent that died very conveniently on January 1, 2024, the last step would be to file the tax return, which wouldn't be due until April 15th of 2025. So we may have everything checked off except that tax return, but I just like to make sure that everyone knows that it can span a little bit longer just because of that last task. All right. So the next slide covers the role that everyone plays. So there's 3 roles that we're concerned with in an administration. Sometimes there's only 2, but most of the time there's 3. There's the personal representative, or I'm going to refer to them as the PR throughout this presentation, more commonly maybe known as an executor. They're going to have the duty to secure the will and the estate plan, make an inventory of assets, provide an inventory to the interested persons, appraisals, and the big P, probate. So the PR or the executor duties only applies to estate assets, so those not in trust. And there are some specific duties for estates, but there's a big overlap between those responsibilities with the trust as well. So some of the trustees, these aren't all inclusive. Some of the trustees' duties are they have a duty to obviously administer the trust. They have a duty of loyalty. They have a duty to be impartial to beneficiaries, which is sometimes a little weird when you are yourself the trustee and also a beneficiary. You have a duty to inform and you have a duty to report as well. So this is just a bullet point that I want to point out that both of these roles really can be a full-time job. So if anyone needed some sort of validation, let me be your validation on that. They can fully be a full-time job, and that's a lot of the times when we're working with trustees or personal representatives, they say that. They say it feels like a full-time job. So here's the confirmation that that is true, and that's sort of the feeling that happens. And the last role is, and you might be saying to yourself, well, Mackenzie, it looks like I'm doing all the work as the personal representative and the trustee, so why do I need an attorney? Well, the attorney plays the role of advising you as trustee or PR, or even if you have a corporate trustee, they don't practice law, so they need a lawyer as well, on how to comply with all of the requirements of both of those roles. And that's our little attorney guy saying, here's the thumbs up, and that's what we do all the time with our clients. We give them thumbs up to do what they need to do. Okay. So the next slide is the meat and potatoes of this presentation. It's the three problems that my team and I have sort of bucketed as umbrella problems to go through some case examples where we're providing you solutions to these problems. It's, again, by no means an exhaustive list, but these are the three biggest pain points that we see in an administration that we're going to help you avoid tonight. So the program is sort of set up where we're going to go through case studies that have happened, and then we're going to explain how to fix them, or at least try to fix them to make things better, cheaper, more efficient for you as a PR or a trustee. Okay, so the first one is the PR or the trustee doesn't know what to do or how to do it. Okay, so this one, it does happen a lot. The trust is descriptive, but a lot of people, when they read it, they don't necessarily know what step one is. It's definitely a roadmap for someone who's read them 100 times. For instance, I would know how to read them, but it wouldn't necessarily be that apparent to someone who doesn't read them every day. And it's an all-inclusive document, but it's very long, it's verbose, and it's a difficult read. It puts a lot of people to sleep. So we're going to talk about some cases where the trustee doesn't know exactly what to do and what the fix is on that. You don't want to let your role as PR or trustee ruin your familiar relationship. So we're going to talk a little bit about that. And then the third one is when the grantor or the decedent received bad advice, and now the PR or the trustee is dealing with it. So that's kind of a combo of problem number 1 and 2. And it's not fun for anyone, but I think we have 1 or 2 examples that we're going to go through about that. Okay. So like I mentioned before, the format of this is we're going to talk a little bit about case studies specifically that have crossed my path and my team's path. And they're not Borchers Cusano Trust Law clients. They're from outside estate planning firms, but it's just easier to talk about actual cases and give actual solutions than to make up hypotheticals that might not happen. So in the interest of everyone involved, we've changed a lot of the identifying characteristics of everything, so no one will be able to identify these people, but we just want to note that. Okay. So the first problem, when the PR doesn't know what to do or how to do it. The first case study that we're going to talk about is, what do you mean my college tax class from 1983 does not make me a tax expert? So in this case, the surviving spouse was a trustee PR in his combined wife and his estate plan. And after she passed away, he read the document and he thought he understood what to do for tax purposes. He had a little bit of tax background to the tune of a class from 1983, and he started checking things off his to-do list. And he thought he was doing a great job up until the Mass DOR had a question for him that he could not answer. And the problem here is he just didn't know what he didn't know. The fix is always let a professional do it. You want to reach out to a CPA or maybe a corporate trustee or a trustee services company. You want to make sure to hire them, or better yet, you can even appoint them in your estate plan so that they can hit the ground running with tax questions like this. So the next case I want to talk about is, I'm calling it Brotherly Love, a tale of feuding co-trustees. So in this case, mom named brothers that never got along during life co-trustees of her estate plan. And it's a beautiful thought. She thought that her death might bring them together to administer everything in harmony. And did that happen? No. And they ended up having a stalemate on everything. They couldn't even file one life insurance claim because they wouldn't address an envelope to each other. It was that bad. So there was no meeting to get anything done. They just couldn't agree, and it caused a stalemate. So the problem is they didn't know how to move forward. So what's the fix here? How do we get them to move forward? Well, don't even pass go. Don't collect $200. Have them each resign and appoint a neutral third party corporate trustee. It'll make everyone happier in the end. It's not worth the fight. All it does is waste time and money and efforts. And in the end, the cost will definitely be well worth the headache. So that's how we fixed that problem. Okay, and the last case study is the trustee already runs a Fortune 500. They do not have time for another full-time job. So this one's interesting because dad had the great idea of putting his most capable son as the trustee and PR of his estate. It's a great idea. They have great executive functioning skills. They have great communication skills. The only problem is the day job of the trustee is grueling. They were constantly working 18 hours. They were actually traveling over the pond constantly, and they had their own family. And this particular trustee personal representative wanted to make sure that they were honoring their parents' wishes, but he just did not think he was capable or going to be effective to get things done as fast as they needed to, or he just didn't think that he was going to be effective. So the first question we really ask is there anyone else in the family that could be helpful in this matter? And there wasn't really anyone else in the family. His sister had a disability and his brother had an addiction problem, so he didn't want to go that route. And he also didn't want to ignore his dad's wishes where he was serving. But there's a solution. You can get a corporate trustee to act as a co-trustee and do the heavy lifting, and you can still have you can still sit and be involved with mom and dad's estate plan to the extent that you want to be, but it might just be easier and more efficient to have a corporate trustee involved. Okay, so just to sum up those three, how do we fix this problem? You're going to ask for help. That's really the big solution. Okay. So our next bucket of case studies is going to address problem number 2, when the PR of the trustee doesn't know how to manage their own expectations or their family's expectations. This is probably the one we deal with the most, maybe. I don't know. I hesitate to say that, but anyway. All right. So the first one I'm calling mom and dad had better traits than organization. So mom and dad had an estate plan with multiple trusts, beautiful estate plan, named our eventual client as trustee and PR. Mom and dad were pack rats, as so many of us are. And dad, had amazing traits, but he might have always left the tax documents in his garage workshop. Mom put everything in the everything drawer in the kitchen where things fall into the abyss. We all know that drawer. It has a million bread ties. And the trustee just couldn't find anything in the home. They had no filing system. He knew that they had a perfect estate plan, but there ended up being missing pages from the original documents, and some of them were covered in gunk from dad's workshop. And the real problem with this one was that the lost pages were actually the siblings' distributions. So it wasn't like the administrative pages that were lost. It was really the meat and potatoes of the trust. And that led to some disagreement between beneficiaries, which the problem ends up being, you're named trustee PR. You thought this would be easier. Mom and dad told you the entire time that they had a great estate planning attorney, that things were buttoned up. And they told your siblings this, and it ends up not being the case. So how do we fix this? You need to just set expectations with yourself and with your other beneficiaries. And again, I'm going to reiterate the problem from number 1. If you can't set expectations, it's always a good idea to hire a professional. So if you're serving as trustee or PR with one of these situations, we would have you ask yourself, just as a gauge, how organized were mom and dad during life? That's always a good gauge for how their assets and their taxes and even their estate and trust will be organized. So you just need to understand what you're diving into before you get there. If everything was a treasure hunt during life, it's probably going to be a treasure hunt at death. There's nothing wrong with that. You just need to communicate with your siblings and remind them that mom and dad may have not been perfect. But dad always forgot the cranberry sauce at Thanksgiving, or mom was always late giving the tax forms to the accountant. So that's just the way they were, and they were great. They had wonderful traits besides organization. Mom might have made the best chicken noodle soup. I know my mom does. Hi, mom. Shout out for my mom on here tonight. And maybe dad gave the best hugs. They have way better traits than organization. So just focus on the positive, and remember that if that doesn't work, you can always hire a professional and let them be the bearer of bad news for your siblings. So everything is fixable with a professional and with expectations that are set with beneficiaries and yourself. In the end, I feel like people are going to ask me what happened here. Well, we did avoid court, but there were some substantial legal fees to settle the situation between siblings. But in the end, the beneficiaries were only mad at me and Emma. So that was a win for everyone. Okay. The next case study, we've had this happen a couple times this year, so I just want to specifically mention it. But this one I'm calling, but cousin Fred still lives in mom's basement. So we've had a couple situations where the trustee maybe has a cousin or a distant relative that's living in the house that's not necessarily a beneficiary of the trust or the estate that owns the home. And eventually that house needs to be sold. So because he's not a beneficiary and he had no means to purchase the home outside of the estate or the trust, we need to communicate with him in an effective way to make sure that he understands what's going on. So in this case, there were words between cousins, and there was a feud that began, and rightly or wrongly so, Fred thought that he was being kicked out by his cousin, which was completely opposite to the generosity that mom had extended to cousin Fred during life. So the problem is that there doesn't need to be a situation where there are feuding cousins. The fix is transparency and communication. You need to set expectations as a trustee or a PR. We would recommend that you set a date that Fred has to be out. You don't need to kick him out. You need to communicate. If you feel uncomfortable doing that, I'm just going to keep saying this, that you can hire someone to give the bad news to Fred and do the dirty work. But communication really saves legal fees, and it will, be the best for Fred in the long run. It's going to take a while to clean out mom's house, so maybe Fred can help with that. He can do the heavy lifting. We can give him a date to be out, but it's better to have him involved in communicating than the latter. So that's the fix for that one. All right, and the last one is, this is not how it's done in the movies. So this may be over a bigger topic, but this is just specific to one client. PR and trustee were of mom's and dad's estate. They were first timers. They had never done it before. They had heard about it from the movies, which is sort of my biggest nightmare when clients say that. But mom and dad were good. They had kept up to date papers. They consolidated their assets during life to make things easier. They set up lifetime inheritance trust. All was well. And then at the funeral, there was a beneficiary who came up and asked the PR, the trustee, when he would be receiving his check, which is not great to ask at a funeral, just as a common courtesy to everyone. But I think there was this expectation that people would be meeting after the funeral to sit around a table and receive their checks from their inheritance if they knew that they were beneficiaries. So it's not like that. There's no reading of the will. There's no checks after a funeral lunch. Films widely misrepresent this, and it does make for really, really good TV. But if that's a beneficiary's only expectation and only involvement with the trust and estate, or if that's a PR or trustee's only involvement, it's really hard and requires a lot of communication to sort of reset those expectations. So The big problem here is no communication and no discussion with your kids prior to death. So if you have an estate plan, it's just important that you let them know it's a complicated document and it's going to take some time to avoid those questions at your funeral. The bigger thing to how to fix it is just talk to them, keep things transparent, send, if you're a PR and trustee, you want to send regular email updates or have your corporate trustee or attorney do so. It's an extremely emotional roller coaster. So everyone needs to be on the same page, in the same book, in the same bookstore, on the same street type of thing. You do want to keep it professional, and you want to tell your siblings that they can ask for help too. They can amicably hire an attorney to keep them satisfied, knowing that if they don't necessarily trust you, that their interests are protected with that attorney's involvement. There's been several cases where I've worked amicably with other attorneys who were hired by beneficiaries, that it just makes the communications easier, it's more productive, and it keeps you from having to navigate the conversation to be productive because emotions are involved. So here's our photo of our family after the oh my gosh, I almost said wedding, after the funeral. Not what it's like. So how do we fix problem number 2? Set expectations and communicate. And I just want to highlight this little cartoon because one of our trust administrators' kids helped us draw these, but they're funny, and there's a few in the following slides, but this one just says, "Kids, you won't fight over my money, right?" And they say never, and then they each have their own weapon, which is very violent but also very funny. We thank Colin for drawing these for us. Okay. The last problem we're going to talk about is grantor decedent received bad advice, and now the PR, the trustee, is dealing with it. So this is probably my favorite title from all of these. The case study is called "Dad had cousin who just passed the bar draft a will over Christmas for $250 and a beer at the 99s." And this is, again, thanks to Colin, we have our lovely estate planning attorney advice for 5 cents. Dad would love that deal. But then down here, accurate advice costs extra. The attorney is in. So the facts are sort of in the case description just because I love them so much. So this is it's a true story that one of our clients that came to us who was a personal representative had his cousin drafted a will for $250, and it went to probate, which is, it was a mess, but it wasn't that wasn't the big issue. One of the things that I just like to talk about is that if you only have a will and you go to probate, the will will be published for all the world to see. You only need you only need the internet and basic math skills to calculate beneficiaries' individual inheritance. So it's sort of like the lottery. If you win the lottery, you don't want to sign that ticket. You want to get a trust to sign the ticket so that you keep the winning private, right? So with trust-based planning, that prevents it. It doesn't prevent it with will-based planning. So with a pour-over will, the trust is the only named beneficiary, so you can't glean a lot of information from that published will. So anyway, back to this very poorly written will. Dad's will named individual beneficiaries. Some were alive, some were dead, some the son knew, and some he didn't. There were charities. It was a treasure hunt to track people down. All in all, I think the biggest issue was there were some fun calls from family members that were not put in the will, and ex-boyfriends, neighbors from down the street. Roger, who needs a loan for his new Corvette, got a hold of some of the beneficiaries in that will. So, Dad got a deal, but the personal representative is now dealing with angry beneficiaries, and it's a big old mess. So the problem, angry beneficiaries, what can we do? Might be too late. Well, it is too late for Dad in this case, but don't let Mom make the same mistake. Do a trust, set it up during Dad's administration. The pour over says very little, and it's going to protect you from Roger down the street. It's going to protect your beneficiaries from Roger down the street, knowing their share of the estate. So, all right. So we're going to learn from mistakes during administrations. All right, so that concludes the discussion about the case studies. So I hope it sort of jogged your memory of some good war stories that we can discuss in a Q&A next, but I just want to share this slide, which has a lot of good information about our upcoming seminar, which is going to be May 22nd at 6:30. It's going to be in person and on Zoom on how to pass down your vacation home, and it's going to be hosted by attorney Tim Borchers. And then if you have any questions or specific needs, we have the contacts here that you can reach out to. Trust Officer Paula Nolan for all your NPT needs, and estate administration, my paralegal, Emma Zimmerman. So I'm going to give you a second to sort of take a picture of that. And then I just want to highlight that we have the After Death ebook, which I noted in the first slide, that covers more about the first 30 days should you need it. And that's on our website as well. So I'm going to leave this up for a little bit, and then I have to X out of this, but I will put this back up after we see if there's any questions. So the first one I'm seeing right now is, do beneficiaries need to know what everyone inherits? That's a really good question. So from an estate point of view, where there's just will-based planning, they're going to know, or they can know, because the will is public knowledge. For trust-based planning, at the time of the first death, not necessarily. At the time of the second death, it's sort of going to depend on what the beneficiaries are requesting in terms of an accounting. So they're most likely going to see the other beneficiaries share. So if you have two children that are splitting it 50-50, they're going to see that, yes. The question was, am I able to practice in Maine? Not yet. I would love to retire there someday, so that might be a little catch-22 there. But the goal is to be able to practice in Maine, but I don't currently. But I do have an attorney in mind should you need that. Jillian, I'm seeing your question. I would have to do a further dive on the specific trust that you're speaking about to answer that specifically. So I'm going to have you reach out to either Paula or Emma if you need it answered, and we can go ahead and take a look. And Richard, back to your question, no one in the practice is licensed in Maine right now. This is a good one. If you want to have your children be the trustee, what qualities would you recommend for the one you select? Good executive functioning skills, good communication skills. Maybe a background in tax and a familiarity with financial vehicles, assets. You want someone who really knows investments. Those are probably the highlights. What is the best way to deal with personal items in the home? That is my favorite question. Tangible personal property is its own, I don't want to say problem, because it's not always a problem. How am I going to answer this? So if all the beneficiaries get along, it's best to just divide and conquer. If you're cleaning out a house, especially, have everyone come and sort of pick and choose. I am going to sort of put a caution to the wind with that, because it is in my practice, been the most, I guess I should say it, the best way to waste legal fees is to have a problem, is to fight over the lawnmower with your brother. So that's a really good question, Richard. And I think it would really depend, my advice would really depend on the facts with your family. Mom, that is too hard of a question and beyond the scope of this. My mom is asking, would it be better to do financial distributions before you die?
And die with my
that is way beyond the scope of it, but we can talk about it on the phone when I'm driving home. If you do have questions about that, that's an estate planning question, and I'm going to defer to our estate planning attorneys on that. So if you have questions about that, they can definitely go through your assets and explain if that's best for you and your family. All right, it looks like there's people leaving, so I think that's a good indication that we got through most of this. Again, we're open to all questions. We want to help. So I'm going to put the slide back up. That's going to give the contact information again, and we look forward to talking to you. Okay, so everyone take a photo of that. And if you have any more burning questions tonight, feel free to reach out. But it's been a pleasure, everyone. I hope you have a wonderful night. And unfortunately, if you're in Massachusetts, I think it's going to rain again tomorrow. So we got 2 nice days of spring, but now it's back to winter.
Thanks, Mackenzie.
Thank you.